Many people think that my father's property will automatically come to me, but that's not legally always true. When a person dies without making a will, it is called intestate death. In such cases, the property is distributed as per the applicable succession law. For example, if you are a Hindu, Buddhist, or a Sikh or a Jain, the Hindu succession law of 1956 will apply to you. For Christians and Parsis, the Indian Succession Act of 1925 applies. And for Muslims, the succession is governed by the Muslim personal law or the Sharia law. Now, suppose a Hindu dies without making a will. There are 4 types of heirs. In the class 1 heirs, it is the mother, son, daughter, and wife. All get equal shares. If the class 1 heirs are not present, in class 2, there is father, sibling, and grandchildren, or siblings' children. Then in class 3, there are agnates which can claim the property, which are nothing but blood relatives of the father's lineage. And lastly, cognates can make a claim, which are nothing but distant blood relatives of the mother's lineage. If the father was a Christian, the Indian Succession Act of 1925 applies. If a man dies leaving a widow and lineal descendants, 1/3 goes to the widow and 2/3 goes to the lineal descendants. That means children and grandchildren. And mother of the deceased does not get anything. Parsis are also covered under the same Indian Succession Act, but they have special provisions under the Act. So the same formula cannot be applied blindly on the Parsis. Now, if a Muslim father dies, leaving behind a wife, son, daughter, and a mother, then the wife gets 1/8 of the share because the children exist. The mother gets 1/6 of the share because the children are there. The son gets a residuary share, and daughter also gets a residuary share, but daughter gets half of the son's share. So in Muslim personal law, there are fixed shares, and the law keeps on getting complicated in each of the religion when the class 1, class 2 heirs are not there, or if there is a stepson involved or stepdaughter involved, and a lot of complications are also involved if the property is actually self-acquired or inherited. And most importantly, if the will is not there, the legal cost keeps on increasing. You have to hire a lawyer, he has to get a succession certificate, legal heir certificate, letters of administration, court petitions, valuation, stamp duty, and the entire documentation. The time taken is much more because the buyers will not act till the actual legal heirs are identified and the bank account money, demat accounts, mutual funds, property remain unsold till all this is resolved. The property remains unmanaged. Nobody takes responsibility for the repairs, maintenance, society dues. Tax complications arise because if the property earns any rent or the FDs or the mutual funds earn any income like interest or dividend, there is nobody to pay the tax on that. So a will is not only a legal document, it is a peace of mind document for the entire family. It saves cost, time, tax complications, and disputes. Share this